In Unit 2, we're going to discuss the display of your license, dealer ethics, license suspension and denials. I'm going to go over the disciplinary fine matrix and the enforcement division, dealer complaints, dealer insurance, your retail contract bill of sale, odometer disclosure and tampering, sales to minors. We're going to delve into our records and records inspections. And then I'm going to talk about the Texas Department of Motor Vehicle Board. So the first thing I want you to really be aware of is that all Texas dealer licenses must be displayed prominently. This is a state law. When you receive your license, you must display it prominently. You don't want to place it in the back of some desk drawer or file cabinet or something like that. You need to place it on the wall in your office. And, you've worked very hard to gain your dealer's license. You're going to be very proud of it. So you need to make sure and display it. It is a Texas state law. So if you ever get a surprise inspection from Texas Department of Motor Vehicle Enforcement personnel, they will verify that you have your license displayed conspicuously. So remember, all Texas dealers' licenses must be displayed prominently. I want to talk about a very important component of your new business, which is ethics. It is imperative that you operate your new business with complete integrity and the highest ethical standards at all times. You're going to need to follow every state and federal guideline on every transaction, period. If you don't operate strictly under all state and federal guidelines, your dealer's license could result in suspension or revocation. Once you've had a dealer's license revoked or suspended, it's very time consuming and can be very costly, when it comes to legal fees for legal representation in order to obtain another dealer's license. Being completely honest with every one of your customers is a win-win situation. You're going to build your reputation your first few weeks in business, and you want to make sure that you build an ethical reputation. A good positive selling experience with a customer will lead to more sales to that customer's friends, to their coworkers, and to their family. A bad negative selling experience will result in customers leaving negative reviews of your dealership all over the internet. It is very easy for a customer to leave a negative review and comments on Google, Facebook, Twitter, and more. When future customers see these reviews, they will not purchase vehicles for you. Customers want a dealer they can trust. To maintain your honest reputation, you must offer full disclosure on all vehicles before the sale. Always disclose every mechanical malfunction that you're aware of before the test drive. By disclosing everything you know about a vehicle before the test drive, you're going to build an incredible reputation in your area. Unethical dealers can really never discard a dishonest reputation. By operating your dealership with complete honesty and the highest ethical standards at all times, you are going to gain that honest reputation that's going to lead to many, many more sales than that of a dishonest dealer. Being completely honest with your customers is a win-win situation. You're going to have your best reputation in your area. You're going to have the highest profits, and you're going to be in business for many, many years. Operating your dealership with complete integrity and 100% compliance equals more profits while ensuring that your dealer's license will never be suspended or revoked. So let's talk about reasons for suspension or revocation of your dealer's license. When you're granted a dealer's license, the state of Texas is basically giving you an opportunity to enter a business field that can be quite lucrative. It can be very profitable. However, you must follow several sets of rules and guidelines that we're going to be discussing throughout this course. All Texas motor vehicle dealers must follow the laws we discuss, and the Texas Department of Motor Vehicles has zero tolerance for any dealer that does not follow all the rules. Any dealer that does not comply or follow the rules can have their dealer's license suspended, revoked, or pay extensive fines. Reasons for suspension or revocation of a Texas dealer's license. Okay, if you're following along in your manual, you can certainly read these with me. But, falsifying or forging any documents. A dealer may not falsify or forge a title document, including an affidavit, making application for certified copies of titles, filing false or forged documents. So obviously we can never file false or forged documents, keeping open titles. A dealer may not fail to make an assignment of a basic evidence of an ownership, including any type of title for that vehicle. And this is called an open title. And an open title is basically one that has a signature on the back and it has not been completed correctly at the time of the sale. Receiving, holding, or delivering an open title is a violation of the law, and it's a very risky way to conduct business. An open title is kind of like a blank check. And we're going to cover that really extensively later on in the course when we do our titling sections. I'll show you some examples of an open title and how to ensure that you avoid ever possessing an open title. Not assigning titles. You may not fail to assign any basic evidence of ownership, including that certificate of title for the vehicle that you're selling. Misuse of plates or tags. A dealer may not permit the use of a metal dealer's license plate or dealer's temporary tag on a vehicle that the dealer does not own or control or that's not in stock. And we've got a whole section on how to use your metal dealer plates as well here later on in the course. Making material misrepresentations on the application. If you misrepresent a fact on any application to the department, whether it's a false statement of ownership or a false response to a felony question or a designation of, false place of business, this is a serious violation. So, such violations can result in the minimum denial of the application and can result in possible civil penalties. So we need to make sure that all paperwork that we ever submit to the state is true and correct. Failing to maintain your qualifications for your GDN, for your dealer's license. The initial requirements to get a license must be maintained throughout your licensure period. And this includes all requirements. Your sign, you can't take the sign down, 6 months after you've been in business. You can't stop maintaining your business hours. You got to make sure that you've got your office requirements. You can't stop having a phone, okay? The department may deny any application or even revoke or suspend an outstanding license, impose civil penalties, or even give a license probation for any person that has not been following, everything that is in the state law. Civil penalties for violations can range from $50 to $10,000 per violation per day. And I'm going to show you the fine matrix here in just a little bit that explains fines for any type of dealer infractions, okay? The department shall cancel a dealer's license if the dealer obtains the dealer's license by submitting false or misleading application. And also refusal to provide evidence of being business. You may not fail to provide the Department of Motor Vehicles within 30 days after the date of demand by the department for any type of evidence that you're still actively engaged in business. So, if they hear that you've closed your doors and they want proof of this, you've got to submit that in a very timely manner. Not remaining regularly and actively engaged in the business. Those people who are not really in business, as dealers sometimes will carry a license for some other nefarious purpose. So maybe they just want a license to avoid paying sales tax on their personal vehicles, or possibly they want to access an auction to buy vehicles. Regardless, those persons who make fewer than 5 vehicle sales per year will have their license challenged. Okay, so we need to make sure that we're selling at least 5 vehicles. Texas law now requires tax appraisal districts to turn into the Department of Motor Vehicles the names of any dealer who either fails to file your annual vehicle inventory declarations, and I'm going to talk about those here in a little bit, or if you do not sell 5 vehicles within the calendar year, then your county will turn that information over to the state, okay? Wholesale transactions will count towards those required 5 sales. So maybe you sold 2 vehicles on the lot and 3 wholesale. I think you're probably going to sell a lot more than that, but all vehicle sales do count up as your totals. Failing to report or pay taxes. Although, the MVD does not collect taxes, those dealers who fail to properly report and pay state sales taxes or inventory taxes could result in additional penalties and revocation of the license from the Department of Motor Vehicles. Misuse of your dealer's license. Misuse of a license involves the use of a license for purposes that are specifically contemplated under the dealer law. Lending license numbers to unlicensed entities to buy or sell vehicles, that's a big no-no. Using the dealer location for illegal purposes, those are examples of misuse of the license. Off-site sales and curb stoning. Dealers are not allowed to sell vehicles from anywhere but their duly licensed premises. Dealers are strictly prohibited from curb stoning, which is the practice of selling vehicles away from a dealer's licensed location. Remember, all retail sales activity has to take place at the licensed retail location. Dealers are also subject to penalty if they aid and abet curb stoning by selling vehicles to persons who practice curb stoning. Failure to apply for the title within 30 days of the date of the sale. The most common complaint received by customers is that they have not received their plates or title to the vehicle within 30 calendar days of the purchase. There are only two valid defenses to this violation. The first defense is if the consumer has misrepresented their credit history on a credit application. In that instance, the dealer has the right to rescind the contract. The second defense is if the dealer has promptly paid off the lien holder of the vehicle, but the lien holder has failed to issue a release of lien within 10 days of the payoff. This is known as the lien holder excuse. A seller finance sale allows 45 calendar days to apply for the title. Dealers are exempt from transferring title for certain vehicles based on vehicle weight. Giving the title work to the customer. Since January of 1996, dealers are required to apply for the title and registration and never give the paperwork to the customer. The tax assessor collector offices have been very cooperative in turning in paperwork to the Department of Motor Vehicles that have been filed by the customer who bought the vehicle from a dealer. The only exception to this rule is when a customer is taking the vehicle out of state immediately, then the dealer should have the consumer fill out the comptroller sales tax exemption certificate for any vehicles that's taken out of state. This form is kept in the dealer's sales file in case of an audit. Remember, dealers have 30 calendar days to provide the buyer any necessary forms to register in their state. Incomplete or no records. Rules require records to be kept for at least 48 months. Remember, the current and immediately preceding 13 months must be available for inspection at the dealership location. Records from the prior 35 months may be kept either on the license site or off-site within the same county. Failing to keep records at all or incomplete records is a very serious violation. Not responding to requests for records. Not keeping records is a serious violation, but not producing those records when a representative appears at the dealership is even more serious. Most information is required by the Department of Motor Vehicles through certified mail. That request would come from certified mail. If a dealer fails to respond to this mail request, it is a violation, and the agency representative may travel to the dealership to inspect not only the requested information, but the general state of records overall. Forgery and fraud. This encompasses odometer rollbacks, title fraud, fraudulent sales of reconditioned vehicles. Also in this category are credit fraud or commercial fraud, floor planner fraud, and that's when the dealer auction or a floor planning company has loaned you money for the vehicles on your lot, which is sometimes called a floor. So, if you sell that vehicle that was purchased under a floor plan and failed to pay that floor plan down, that can actually be what's known as floor planner fraud. So also consignment fraud, which usually goes hand in hand with all of these activities. In all of these instances, the perpetrator has made representations that have induced someone to buy a vehicle that he or she would not have purchased but for the fraudulent representations. Fraud is also cited as when a dealer files a false tax or any type of false title documents. Spot deliveries. This fraudulent practice consists of selling and delivering a consumer a car after signing a retail installment contract and then calling the customer back into the dealership to sign a new contract with a higher interest or maybe higher payments or to put more money down. This practice happens a lot when a dealer wants to tie the customer to a sale but is unable to verify credit in a timely manner. Dehorsing. Dehorsing is done in conjunction with the spot delivery and occurs when the customer refuses to sign a new contract and demands back their trade-in, and they're told by the dealer that the trade-in has already been sold, thus forcing him or her into a new contract of a vehicle possibly of a lesser value. Parking on the right-of-way. Dealers are specifically prohibited from parking or displaying vehicles on the right-of-way adjacent to their dealership premises unless the governing body having jurisdiction over that easement, right-of-way, or driveway expressly consents to such use in writing. Use of right-of-way property that is part of the state highway system may only be authorized by a lease agreement entered into with the Texas Department of Transportation. This permission is given very seldom due to the nature of the safety hazard involved in allowing cars to obstruct the view of oncoming traffic. If a dealer wishes to inquire as to written permission, the dealer should call their local Texas Department of Transportation office. Failing to settle civil fines. One sure way to lose a dealer's license permanently is to refuse or neglect to pay any civil penalties assessed against the licensee by the department. Odometer tampering. Dealers are strictly prohibited from fraudulently tampering with an odometer to reduce the number of miles indicated on the odometer. This is a federal and state law with some very serious criminal penalties. And we're going to cover odometer tampering extensively in another part of the course. Besides the criminal penalties, a person could be permanently denied a dealer license upon such convictions. Does not maintain your established place of business. So you can't just close your doors or move across the street or something like that. Use of false or deceptive advertising. We have a whole extensive section later on how to correctly advertise your vehicles. Failing to notify the Texas Department of Motor Vehicles of any type of license changes within 10 days. Failure to notify the DMV of ownership changes within 10 days. Failing to notify the MVD of a mailing address change within 10 days. Also, failure to maintain your dealer surety bond during your entire licensure period. You can never let your dealer surety bond expire during your licensure period. If you are a current dealer, then you have to have a dealer surety bond. Also, failure to file your annual vehicle inventory tax. We're going to talk about how to do that here in a little bit. Failure to file your monthly tax. We're going to go over these extensively here in a little bit. Failure to sell 5 vehicles per year. So if you only sold 4 vehicles in 1 year, you will not be able to renew your license the following licensure period. Premises violations, including bond violations, filing false tax statements. For example, I'm going to go into this. Say a dealer sells a vehicle to a customer for $4,000, but then on the title paperwork, you mark $2,000. This can happen to you, okay? You can have a customer come in and say, hey, I'm giving you $4,000 for the vehicle, but I want you to write down $2,000 so I can save a little bit of money when I'm registering it. This is a big no-no, big no-no. And I can almost guarantee you there's an excellent possibility that you will have some customers in your dealership that are going to ask you to write down a lower price. So sometimes you're going to have to realize we might just have to put that pen down and walk away from the deal because unfortunately, I predict you are going to have some customers in your dealership that are going to ask you to write down a lower price on all the title paperwork than the actual selling price. Here's some reasons for denial of your dealer license application, okay? As I've said several times, false statements of material fact. We've got to make sure our dealer license applications are correct. If you committed certain types of felonies or fraudulent acts or felonies or misdemeanors involving a motor vehicle, if you don't have a place of business, obviously you can't get a dealer's license. Do not have that working phone. You don't have a display lot or area. You got to have that. This is part of the gig, okay? They also want to make sure your display area is always physically separated from another business's parking. So as I said earlier, the state wants to make sure you don't have a neighboring business who's accidentally parking on your lot and then someone thinks that vehicle's for sale. That's confusion the state wants you to avoid. Maybe your business is not physically separated from another business. So, dealers must follow every law, every rule, and every guideline that we cover here today in order to operate a successful and profitable dealership. Any dealer that does not operate completely within the law will face fines or possible license revocations. Next, I want to talk about the very important to know disciplinary fine matrix. Texas dealers that do not follow every law, rule, and guideline may face civil penalties of up to $10,000 for each violation per day of continuing violations. And that's according to the Texas Occupations Code 2301.801, Chapter 503, if you want to look that up. The state may also revoke a license for any violation. The Texas Department of Motor Vehicles maintains what's called a disciplinary fine matrix that is intended to give dealers a general guideline for how the department determines the appropriate sanction for most common violations. The matrix does not contain all possible violations, nor does it limit the department from seeking sanctions outside the disciplinary matrix, recommended low and high sanctions when circumstances require. Aggravating and mitigating factors. In determining the amount of civil penalty to assess, the department will consider the following aggravating and mitigating factors. They'll consider the seriousness of the violation, including the nature, circumstances, extent, and gravity of any prohibited act, and the harm or potential harm to the safety of the public. They'll also consider the economic damage to the public that was caused by that violation, the history of previous violations, and the amount necessary to deter future violations, and any other matter that may include history of violations of similar nature, the number of violations, or attempted concealment of the violation, or any intentional or premeditated, gross negligent act constituting a violation. And, in determining whether the revocation is appropriate, the department will also consider whether the licensee is unfit under standards governing the occupation, and also whether the licensee made any misrepresentation to the department, and whether the licensee willfully defrauded a customer. So, in determining the amount, they're going to use, the acknowledgement of wrongdoing, the willingness to cooperate with the department, efforts to correct the violation, and any other mitigating factors. So the Texas Department of Motor Vehicle fine matrix is what we're going to be going over here in just a moment, because it sets fines for certain violations of state law, and they're set right into the matrix and written into the Texas Occupational Code and the Texas Administrative Code. And it clearly states the punishments for Texas motor vehicle dealers that violate the law. So I'm going to show you here in just a moment. I'm going to show you the low sanctions, which will normally set the minimum fines for punishment, and the high sanctions, which will normally set the maximum fines. And these are all going to be dependent upon the circumstances and the specific case. The minimum or maximum penalties and fines that can be changed are dependent upon the severity and number of violations. So let me show you what I'm talking about here. Here you see the Texas Department of Motor Vehicle Dealer Fine Matrix. So as you can see right there at the very top, if you willfully defraud a customer, the fine starts at $1,000 and can lead to revocation of the license. Falsification or forgery of tax documents starts at a $1,000 fine and can lead to revocation of the license. And the federal fines for this could actually be more. So be advised, we are just looking at state sanctions here, which would be in addition to any federal penalties under the law as well. Let's look at some more here. Misrepresenting mileage, that starts at $2,000 and leads to revocation, and federal penalties on odometer crimes are usually much more severe. False VIT statements start at $1,000 and can lead to revocation. Let's look at some more violations here, okay? Allowing someone to use your GDN, that actually carries fines of $500 to $4,000, allowing somebody else to use your dealer's license. Take a look at this one. Towards the bottom, they're acting as a manufacturer or distributor. Those fines actually start at $5,000 and can be charged by lead to charges by the Attorney General's office. Look at that one. Curb stoning, $500 starts out up to $2,000. That's going to be your, off-site sales activity. Advertising is a lesser when you don't have a lessee license. Look at this, selling from the right-of-way. You can't do that. Remember, you can get a warning letter, but they can fine you up to $2,000 of that. Okay, so let's take a look at a couple of more here. Okay. Violation of the blue law can lead to fines of up to $2,000. Selling or leasing a vehicle that does not meet emissions can lead to fines of up to $4,000. Overcharging documentary fees can lead to fines of up to $2,000. And we're going to show you how to comply with your documentary fee law later on in the course, so you will never, hopefully, ever overcharge for document fees. Okay, so you can see there, failing to retain compliant buyer identification, overcharging document fees. As I said, no written consignment agreement. We'll talk about consignments a little bit later on as well. Okay. I want you to be aware, if you follow every rule, law, and guideline required for your business, you will never pay any fines and you'll always keep your license. So, if you maintain 100% compliance, that's always going to equal 100% profit. So if you maintain compliance, you never pay any fines, you keep all your profits. I want to really reiterate, 100% compliance equals 100% profit. So let's talk about the Texas Department of Motor Vehicles Enforcement Division, which has oversight over enforcement of laws that involve Texas motor vehicle dealers. Texas laws are enforced by the Texas Department of Motor Vehicles Enforcement Division. And, it's interesting, they receive about 12,000 complaints a year. They investigate limit law violations, and they also respond to dealer complaints. The Enforcement Division receives approximately 12,000 complaints per year. And, Enforcement investigators make contact with licensees and complaints to collect information based on complaints reviewed. Investigators also assist law enforcement by training officers and other agents on rules and regulations that apply to dealers' licenses. The Enforcement Division is made up of 5 sections under the direction of a single director who reports to the Texas Department of Motor Vehicles Executive Director. The 5 sections are administrative, legal, lemon law, motor vehicle investigations, and motor carrier investigations. The legal section employs attorneys that review investigations and, if needed, prosecute violations. Administrative supports the other sections such as human resources, purchasing, accounting. The lemon law administers Texas lemon law and warranty compliance programs that mainly affects franchise dealers that sell motor vehicle motor vehicles, motor vehicle investigations, and also motor carrier investigations are carried out as well. I want to talk to you about dealer complaints. The Texas Department of Motor Vehicles makes it very easy to log a complaint against any Texas motor vehicle dealer. They have several phone numbers, email addresses, and the online dealer complaint form that they can complete at the following website. It's txdmv.secure.force.com complaint. And as you can see here, it is very easy for customers to log a complaint against your dealership by using this very easy to use form. Okay, so we want to make sure we're doing everything in our power to make our customers happy. Okay, we do not want them making complaints against our dealership. We don't want the Texas Department of Motor Vehicles hearing about, Texas Motors in Austin over and over and over and over again from all your unhappy customers. So they're going to basically know that you're not really running your business like you should. So we want to do everything in our power to make our customers happy. If you sold a vehicle to someone this morning and they're coming in the front door this afternoon, we don't go running out the back door. We want to make our prior customer our top priority. Do anything you can to make them happy. Okay, so make sure that you keep them happy, and that's going to be really a very important component of operating any dealership.